The Black Lawyers Association is now into the contestation around the Public Protector, Advocate Busisiwe Mkhwebane. It says the Legal Practice Council should not get involved or consider disciplining her after various calls for the council to take action against her based on a constitutional court ruling that she lied under oath. The BLA goes further, saying it actually disagrees with the constitutional court's finding. It released a statement today quoting from the minority ruling in that court. Last month, the court ruled 8 judges to 2 that Mkhwebane must pay some of the costs incurred in the Absa Bankcorp case personally. Bayethe Maswazi is the head of policy and legislation for the Black Lawyers Association. Bayethe, good evening to you. Thank you so much for talking to us via Skype this evening.
Good evening, Steve.
Why do you believe the Constitutional Court is wrong here?
Well, at least to an extent that it has been understood to mean that the public protector must be subjected to disciplinary proceedings by the LPC. We think there is no basis for now for that in view of the processes that are being initiated in Parliament. And in view of the fact that in the entire proceedings, the public protector was not acting as the attorney or advocate. She was the litigant like any other person.
The Constitutional Court found 8 judges to 2 that the public protector had lied under oath. Are you saying then that if the Constitutional Court finds that someone lied under oath, they should stay in whatever position it is, but they should also stay as an advocate, an officer of the court?
We think that anyone who makes that conclusion should at least read the High Court judgment and try and link the 2 judgments. And when that happens, as we have done, we think that there will be no basis to make a conclusive finding that she actually lied under oath if you read both judgments.
I'm sorry, are you saying the Constitutional Court simply got it wrong?
I'm saying its findings in relation to whether she lied or not are not supported by the previous judgment that was appealed against. That is the High Court judgment.
Okay. Is it not, and if the Constitutional Court makes a finding, I might strongly disagree with it. I mean, I have every right to have a right to freedom of speech, but if from that finding certain consequences must flow, so if the Constitutional Court finds that Stephen Grootes is a liar, would I still be allowed to occupy high office? I mean, surely the general public would be able to ask questions about why Stephen Grootes would be allowed to occupy high office if 8 judges in the Constitutional Court found I'd lied under oath.
As I'm saying, you must find specifically in the judgment a particular reference to her lying. And we are saying the Constitutional Court judgment is not standing on its own. It is based on the High Court judgment. Any conclusion that it might have made would have been based on the High Court judgment. If you do not have a conclusion that the public protector lied in the High Court judgment, where would it come from in the Constitutional Court judgment? We just find that there is absolutely no basis for one to make a conclusive finding that there was lying on the part of the public protector.
Did it not come in documents that she submitted as part of her appeal?
Sorry?
Did it not come in documents she submitted as part of her appeal?
There is no indication in the High Court judgment that this was the case.
In the High Court judgment, but I'm talking about in the Constitutional Court judgment. Did she not submit documents there?
In the Constitutional Court judgment, there is no finding or there is no indication that this was actually based on new information altogether. There was a comparison between what the evidence was before the High Court and the responses of the public protector. And we have not found anything actually conclusive pointing to her having lied under oath.
Okay. You say in your statement that you invite the public protector, Advocate Mkhwebane, to reissue her remedial action in the Absa Bankcorp case. In other words, to change it and to reissue it. This matter seems to have been closed completely now. Why do you believe she should reopen it?
The High Court judgment did not nullify the entire report. It simply set aside the remedial action. It actually made a pertinent conclusion to the effect that the court was not prepared to nullify her report, her entire report. In other words, it remains possible for her to look at those defects that are identified by the court in the remedial action and to make a finding. And we do so because the question of the siphoning of funds, of public funds, by any institution, has to be a very important consideration and has certain public interest elements to it.
In your statement, it's a lengthy statement, you refer to legal organizations that have made up their minds on this matter. One legal organization that has done so is NADEL, the National Association of Democratic Lawyers. They called on Advocate Mkhwebane to resign on the basis of the Constitutional Court ruling. Can I presume that you're talking about them in your statement?
Yes, partly. You will recall that the NADEL statement was issued immediately after the judgment was released. And in our view, we feel that that was relatively premature for them to have studied effectively and understood the judgment. And it was really premature, but especially for a professional lawyers organizations like them.
Okay. You've written an extensive statement, Bayethe. I mean, you've examined the law very closely in your statement. It's important. So to look at your statement, there is a principled argument based on the law that I think is being put forward. But let me just ask this question for the record. You can answer it how you like. So if I look at your statement, it looks like a principled argument based on the law, particularly around the power of the Legal Practice Council. The Public Protector at the moment is a fairly divisive figure. I think we could probably agree on that. There is some political element to this. So just to be clear, am I right in presuming your position is only about a principle of law, or is there some sort of political motive here as well? In other words, for the record, let me put it plainly, are you being drawn into the politics of, the Public Protector at the moment, perhaps?
No, we are not a politically partisan organization. We are a rule of law, human rights-based organization. And our interest is the principle relative to the law. We are not interested in the political issues.
Okay, so if, for example, the Legal Practice Council does act against Advocate Mkhwebane, would you be prepared to stand by her? Would you be involved in courts, or would you just support her morally like you are now?
It will not be standing for her. It will simply be standing for the principle relative to the interpretation of the Legal Practice Act that the Legal Practice Council administers.
Do you believe then that there is a political campaign against her? Do you think that that's what could be driving this action?
There is a perception of a certain party political campaigns, but I cannot effectively make a conclusion that those perceptions are actually based on anything, on truth.
Bayethe Maswazi, thank you very much indeed. Head of Policy and Legislation at the Black Lawyers Association.